Good morning, everyone. We're going to let some people still roll through, but I just wanted to go ahead and start. I'm Charina Garcia. I'm the Strategy and Innovation Partner here at WR Immigration. We are continuing our series of chatting with Charlie. And of course, we have Charlie Oppenheim here, and he leads our government relations group. As everyone knows, if you've been listening to our chatting with Charlie, he was the chief of the State Department's Visa Control Unit for 23 years, where he actually controlled the numerically issued immigrant visas. This is, like I said, a continuing series, which we started in December, last December. And this time we're going to actually go behind the scenes of the Visa Bulletin and explain some of the mysteries surrounding the movement of the categories. And with me today, I have Laura, who's going to help me translate and decipher the mysteries of the Visa Bulletin. So Laura, welcome to our panel again.
Thanks so much.
Yeah, so we'll go ahead. And again, our prior series is on our YouTube channel, so you can find us there. Legal disclaimer, of course, this does not constitute legal advice, informational purposes only. If you'd like to schedule a consultation, please reach out. And then just a little bit about our firm. Our firm is one of the top rated immigration firms. We actually provide, we partner our services with excellent technology, and we have a robust database that we've customized and developed using Salesforce. So we invite you to contact us if you're interested in seeing a demo. Again, I'm Charina Garcia. We have Charlie here as well, and Laura. So we'll get right to it. All right, so what are we talking about today? Like I said, we're going to talk about the mysteries behind the Visa Bulletin, and you're going to see some charts which we don't think have ever been publicly seen that Charlie has created. So it's a special edition today. And we're also going to look at the June Visa Bulletin, some predictions, and then the EB2, EB3 rest of world retrogression. So with that, I'm going to pass it to Laura.
So like Charina said, we're going to be talking about and breaking down how the Visa Bulletin works. So very broadly, we're going to ask Charlie, why is the Visa Bulletin published monthly?
The bulletin, we published it, or it is still published on a monthly basis in order to let people know and be able to follow where they stand in terms of the line regarding processing, which cases will be eligible for processing in the upcoming month, as well as being able to have the Visa Bulletin include other important visa-related information, such as there may be a potential retrogression. Here's what we think visa availability will be in the coming months. There may be post-closures. Here's how you contact the National Visa Center, and a wealth of other information would be published in the monthly Visa Bulletin.
Excellent. I know as practitioners, we're always keyed in, and sometimes it feels really dense. It's hard to think that a lot of individuals would be breaking it down. So hopefully we're providing you that context here today. And Charlie, could you tell us a little bit about what's the difference between the final action dates listed in Chart A and the application filing dates listed in Chart B?
Sure. On a monthly basis, the State Department receives information from regarding the amount of applicants who are ready to proceed with final action, their case at overseas post. The Immigration Service also provides information. The State Department looks at that and determines, based on how many numbers they feel are available for use in the upcoming month, and they make a determination of the final action dates, with whatever final action date being listed is the first person who could not be accommodated for a final action on their case in that particular month. The final action dates are not intended to represent future availability of numbers beyond the month the bulletin is posted for. Changes in applicant demand could and has impacted number use and required retrogression of dates. So again, the final action dates represent who can be processed in the upcoming month. That's chart A. Chart B is used that is the State Department in consultation with USCIS officials determines, okay, we have this many people that are ready to go in the coming months, and we think that 8 to 12 months in the future, we're going to need to have X amount of additional applicants become ready for final action date so that we can so the department and USCIS can maximize number use. So what they do is determine the application filing dates to say, okay, we want this amount of people to begin submitting the required documentation so that in 8 to 12 months, when these dates are reached by the final action date, then we'll have demand ready to go, and again, to maximize number use. But so again, the application filing dates just allowed people to file and begin starting their paperwork so their case will be ready for final action at some future point.
Excellent. So when we think about the application filing dates and using the example on the charts here, or like EB2, we're looking at employment-based charts. When we looked at the chart B in the second preference category, we see a priority date of February 15th, 2022. So someone with a priority date of that or earlier could file their application. And how are they to think about when their date would be final action, like ready for approval or issuance of a green card immigrant visa?
The best thing is to continue watching the movement of application filing dates to see if they're holding steady or advancing. If they're holding steady, then the applicant that is within that February 22 date may want to understand that it may be a considerable wait before their turn comes up. But again, that hopefully within 8 to 12 months from today, their case would be ready for action. But one thing I failed to mention in chart A, the final action dates, many people assume that everybody that with a priority date earlier than the listed date has been taken care of. And that it's important to remember, nothing could be further from the truth. Applicants proceed with final action on their case at their own convenience and pace. And literally thousands of people a month become qualified for final action, even though that their priority dates are months, potentially a year earlier than the established final action date. And those people coming forward can have, create volatility in the final action dates, and then also impact whether the application filing dates listed in chart B will be reached within their estimated time frame.
Yeah, that's a good point. We've talked about it in some of our previous chatting with Charlie, so check that out on YouTube. We talked about the lane changes and how that could create some volatility. So that's a good point to bring up. Someone in chart A with a priority date doesn't necessarily have the green card already in hand. So to keep that in mind when you're thinking about movements in the Visa Bulletin. I think let's go to the next slide. So I know this is something, Charlie, that you've prepared a while back for a Federal Bar Association presentation. So some folks may have seen this, and I know that it's been adopted by USCIS to try to break down and understand the flow of immigrant visas and how it all works within the employment-based space. So can you kind of walk us through it?
Sure, it's kind of a confusing document, but for employment first preference, there's a limit for employment first, second, third, fourth, and fifth preference. So if all of the required numbers or all the available numbers in the employment first preference will not be required for use because there's insufficient demand, then those unused numbers can fall to the employment second and would be added to that annual limit. And if there's still unused employment second preference numbers, they could potentially fall to employment third preference. In the fourth and fifth preference, if there's unused fourth preference numbers under that annual limit, say for the example, the fourth preference annual limit were 10,000, and only 8,000 of the numbers were required, then 2,000 of those unused fourth preference numbers would fall up and be added to the employment first preference annual limit. And the same with employment fifth, any of those unused numbers would fall up to the employment first, and then potentially the trickle down to second and third. There is no fall down of unused numbers into either the fourth or fifth preference. Those are, quote, absolute limits on an annual basis.
Okay, that makes sense to me. And thanks for walking us through the graphic and saying what their limits are. Charina, you want to take it from here?
Sure. So now we're going to start talking about how the Visa Bulletin works. So Charlie, can we again talk about EB1 and the worldwide limits?
Sure. What the employment first preference is entitled to 28.6% of the overall worldwide limit. In this example, the worldwide limit would be 56,000. Both China and India are subject to per country limits of 7%. And these 7% per country limits are imposed to prevent a single or a handful of countries from monopolizing numbers. So the State Department would know that there is enough demand in employment first preference for both China and India to hit their limit. So they would subtract those limits from the 56,000 figure. And then they would make an estimate of how many, quote, rest of world numbers will be used in the employment figure or that year. And they would also subtract that. And in this example, the remaining unused numbers is 10,000 numbers. So years ago, Congress established a rule that they didn't want these 10,000 numbers to be potentially wasted if there was sufficient demand by Chinese and Indian applicants. So those 10,000 numbers would then be made available to the Chinese and Indian applicants who had hit their per country limit, and they would be made available strictly in priority date order. This is why that for many years, both India and China, employment first preference were able to be at a current status because there were enough unused numbers. This year, the rest of world figure, when it's subtracted, the amount of unused numbers is less. So that is what has required the India and China first preference dates to be held for a considerable amount of time.
Okay, let's go to the next slide. All right, so what we're going to do here is Charlie's going to explain the redistribution of the numbers. But before we do that, let's define some of these. I know we know what EB1 is, as those are extraordinary ability multinational managers, EB1 outstanding researchers, professors, EB2, so that's master's degree or bachelor's +5 requirement for the position. EB3 is the skilled and the professional. This is where typically all our nurses fall under EB3. EB4, Charlie, can you define EB4 for us?
EB4 is contains a lot of like former government employees, NATO employees, etc., as well as certain religious workers.
Okay, and then EB5?
EB5 is an investor program whereby applicants invest a certain amount of money in a U.S. business or interest, and in return they would receive that interest. Also, besides the investment, has to create at least 10 direct new U.S. jobs. And if the applicant meets those conditions and a visa is available, then a visa is provided to the applicant and their family members.
So we have a separate series that Charlie does for those interested in the EB5 investor green card. But okay, Charlie, why don't you explain this chart and let's talk about El Salvador.
Okay, so I'll start out by the State Department. This is something that's come about because of an item that was published in the March Visa Bulletin that the State Department had reevaluated their policy regarding how family-based numbers could be used in the employment categories. And this negatively, in my opinion, impacted applicants in the fourth preference category. So what in this example, the State Department has determined that El Salvador will have 10,000 unused numbers under their overall family sponsored limit. And therefore those 10,000 numbers from family could fall down and be used potentially by El Salvador applicants in the employment categories. So if we move to the chart, the fiscal year 2023 annual limit announced by the State Department is 197,000. So that limit would be divided among each of the 5 preference categories, with the employment first, second, and third receiving 28.6% of that limit, resulting in a 3,994 for employment first, second, and third. And the fourth and fifth would be entitled to a maximum of 7.1%. So what would happen is that, so that's the normal limit. Then El Salvador is going to have these 10,000 numbers that fall down. So those same percentages I just mentioned, the 28.6 and 7.1, would be applied to that 10,000, allowing these numbers in the middle column, the 2860 and the 710, to be added to the original limits, resulting in the new quote per country limit on the far right. This is what this increased in the fourth preference in this example. This increased limit is what is requiring the retrogression of the worldwide employment fourth preference final action date, to which now there is a single date in 2018. And this is a direct result of there being so many juvenile court dependent cases that are being processed, and most of those applicants have priority dates in the 2018 timeframe. And since El Salvador, Guatemala, and Honduras have a large amount of these applicants with early dates, that is what has resulted in the worldwide date having to retrogress.
Okay, so El Salvador's usage of their EB4 numbers has increased, or they have a lot of folks that have older priority dates, which at the end of the day has impacted the rest of the world. And that's why we're seeing retrogression in EB4. Right?
Exactly, because
Okay.
so many of these from those 3 countries, so many of their applicants are using numbers under the overall fourth preference limit.
Okay, and then what we're seeing now is that because our religious workers are covered under EB4, how that's going to impact EB2 and 3. Laura, what do you think? How's that going to impact EB2 and 3?
Well, now we're seeing more organizations that are, that would typically support EB4 are moving those sponsorships into perm. And now we're going to be seeing those organizations use numbers in the EB2 or EB3 category. So we're going to see further backlogs.
Yep. So I think that's just like a ripple effect, right, of how they change the EB4 category. And then, of course, when they start going into EB3, EB2, it's already impacted, especially for our Chinese and Indians. And I don't know, Charlie, could possibly see further delays?
I think so, because the situation with the date, the final action date being listed in the employment fourth preference, that is not likely to improve in the near future. So the backup of people with later dates is going to, like you said, spur them to move into the third preference. That is going to strain visa availability in the third preference, potentially requiring some of those dates to be held, depending on how many people switch, potentially retrogress at some point.
Yeah, okay.
So it's kind of like you squeeze a balloon, there's a bulge someplace, and the bulge may be in the third preference in the future.
Yeah, well, time will tell, right? We'll have to see. Okay, so now we're going to move on to this next chart, and these are the charts that we believe no no one in the public has seen, that Charlie has developed for us. Now, Laura and we have a little bit of difficulty grasping what Charlie's going to say. So
Okay.
we're going to try and help translate this for you all. So Charlie, let's talk about this. So we're going to do the family-based annual limits. And the reason we're doing the family-based annual limits is because the family-based annual limits actually impact the employment-based limits, right, Charlie?
Eventually, yes.
Yes, eventually, with our little chart that Laura had discussed. Okay, Charlie, take it away.
Okay. The Immigration Act of 1990 was the last major immigration reform that has taken place. And at that time, as there are now, there were many people that said we need to expand the amount of visa numbers available for immigrants coming into the US. And then there were people that said, no, we have plenty of immigrants already in the US. So in order to appease the people that said there are plenty of there's plenty of people already, Congress established a quote ceiling of 480,000. And then they said, from that, we're going to, even though the immediate relatives are not counted against the normal numerical limit, we're going to count them in the calculations. So we will subtract the amount of immediate relatives who received visas in the preceding year from that 480 figure. And also, there's many aliens applicants that are paroled into the US each year. So they said, we're also going to subtract those people from the 480. So see, we're trying to cap the amount of applicants actually coming into the country. And then they said, if all the numbers available under the previous year's employment numbers were not used, then those numbers can be added. So you do all those calculations and you come up with the total, in this case, 63,815.
Okay, hold on. Let me decipher this first. Okay. All right. So you're telling me at any given year, the maximum green cards that we're allowed to issue is 480,000?
In theory, but this is a pierceable, although those drafting the 1990 Act made it appear that this was an absolute limit. It is a pierceable limit because they said when you do all these calculations, if the total is above 200, they said if it comes out above 226,000, that would be the new limit. But they said, we want to have an absolute floor. We want a minimum of 226,000 applicants in the numerically controlled family categories to be eligible to receive a visa in any given year. So if in this case, the calculations only came out to 63,000, which is lower than the 226 minimum established. It's a floor. Therefore, the 2023 annual limit was calculated at 226,000. But as you can see, if you calculate all this, if you go and look at the amount of applicants in the family categories, immediate relatives, and the numerically controlled, that came into the US and will receive visas in 2022, it's probably in the 700,000 range. So again, it's a pierceable ceiling.
Okay, so really, there is no limit to the number of individuals that can get green cards because of this floor that they've created.
Correct. So you've got all the immediate relatives plus in 2022, you had over 400,000 immediate relatives, plus the potential for 226,000 numerically controlled family-sponsored applicants that because of last year's limit. So unless there's a legislative change, the family-sponsored annual limit will always be 226,000 going forward. It is not changed from that total in over 2 decades.
And have you ever seen it fully utilized, the 226,000?
The 226,000 with with a couple rare occurrences, typically number use is within 2%. So normally at least 98% of that 226,000 number limit would be used. There have been years such as the recent COVID issues that have prevented that from being reached. But in most years, number use is very close to, is within 2% of that 226 limit.
Okay. All right, Laura, we got this? Kind of.
I think so. I mean, I think the biggest takeaway for me that I learned from Charlie in our prep was that the immediate relative visas are sort of a subtracting force in this equation. And I didn't realize that immediate relatives had that impact on the family-based caps.
Yeah, as far as I can remember, there was 1 year in the 1990s when this calculation, the total, because of lower number use in immediate relatives and employment, the total was approximately 258,000. So for that year, the limit was, family limit was 258,000. But again, that type of calculation hasn't occurred in over 2 decades.
So it's always set at 226.
Yeah, since
Okay.
probably 1998.
Okay, so now let's go to the next slide. And then let's talk about the employment-based annual limits.
Okay, so the employment annual limit is a much easier thing to calculate. There are not as many variables involved. The Immigration Act says that the employment limit is always a minimum of 140,000 plus any unused family numbers from the previous year's limit. So in this regard, the 2022 family-sponsored annual limit was 226,000. Under that limit, there were 57,083 unused family numbers last year. So those 57,000 are then added to the 140,000 minimum, resulting in this year's 197,083 limit.
Okay, so just to summarize, the family base is always capped at 226,000. And then whatever is unused then will actually roll over to the employment base and then follows that chart Laura said, like EB1, EB2, EB3, and then all of that. Okay.
Correct.
And so that's why the employment base limits go up and down, right? And then we also have to factor in that if there are unused numbers, we look at the annual limits of each country, right? And then if there's any that are unused rest of world, then they go to, right now, China and India, because those are the oversubscribed countries, and it's based on priority date order. Did I A+ this? Did I ace this, Charlie? Did I summarize it properly? Thank you.
Perfectly. It is a very complicated thing, and hopefully people have seen this. And this is something that you may want to go back on and look at YouTube and have more time to kind of look at it. It's kind of a complicated, confusing thing. And as I often say, many of the numerical controls issues are clear as mud unless you have to deal with them on a regular basis.
Yeah, but I think if you have this basic understanding that employment-based numbers and the movement can be driven by the family-based numbers, and then also by the demand for each country, right?
Right.
Which we're going to talk about in the next couple slides about retrogression and stuff.
And again, I think these 2 slides are very important, because people often just kind of assume that, you know, they don't understand how the State Department makes the determination of each year's limits. They kind of think it's magical.
And everyone has to understand that it's based on statute. It's regulatory, right? There are,
yes,
yeah.
There's no, you know, it's not the whim of the State Department. Everything is purely established by Immigration Nationality Act guidelines.
Yep. Okay, so let's go to the next slide. And now we're talking about the employment-based annual limits from fiscal year 2019 to 2024. So why don't we kind of summarize this and walk through it.
Yeah, again, here we see the worldwide annual limits. We see the limit for each of the first, second, and third preference categories there. Each of those categories are entitled to a maximum of 28.6% of the overall limits. So that's where you get the 56,342 totals for 2023. And for each of those categories, the per country limit of 7% is then applied to that 56,342 total, resulting in 3,944 numbers. So the maximum amount, the per country limit for China and India in the employment's second preference is 3,944, is kind of the baseline, plus any potential fall down from either employment first or potential unused rest of world numbers, which, because of the establishment of a worldwide final action date in the employment second preference category, there are no otherwise unused numbers. So both China and India are subject to this 3944 figure, which has resulted in basically the stagnant movement or retrogressions of the second and third preference dates.
Okay, okay. So let's move to the next slide. And let's talk about the immigrant visa issuance trend, right? So this is charting it from 2017 to 2023. What are some of your observations, Charlie, on this chart?
You know, much of it, as you can see, is COVID related. You can see this dramatic drop, and you can see that number use is coming back to and rebounding very nicely as overseas posts and immigration services offices here in the U.S. are returning to a more normal processing status. But the lower limits of this year versus last year and that of fiscal 2021 will have an impact on how many numbers can be used. So
it's actually going up higher in March of 2023, right? Higher than ever, I think.
Right. I think the overseas processing, the State Department's goal when I left was to try to recover as quickly as possible from the negative impact of the COVID on post closures. And I know my discussions at that time with the Immigration Service, their goal was to also try to recover and maximize number use under the annual limits. Both of them are based on staffing and resource implications.
Okay, so now we're going to move to our Visa Bulletins. Next slide, where we're tracking from October 22nd to the most recent Visa Bulletin that came out for June 2023. Red shows the dates going backwards, or what we call retrogression. Green is forward movement. So if we're looking at this, we see that EB2 has retrogressed in April 2023 and May 2023, and it's holding there in June. And then EB3 retrogressed in May of 2023, and it's holding again there at June 1, 2022. With China, good news, we've only seen forward movement, so the green is good. So we've seen forward movement, but again, no changes in the June 2023 Visa Bulletin. The numbers are staying the same as May. And then India, we had a few retrogressions, right? The red there. First October 2022, then December 2022 for EB2, and then April 2023. And then we're holding steady for May and June, no change. And then EB3, forward movement in October of 2022 and December of 2022. And then we've just been holding steady since January 2023 at that date. So Charlie, any observations here or that you'd like to share?
One of the things that I find somewhat confusing and partially it's probably because of lack of availability of data that's being published. But in the employment, the rest of world employment second preference category, except for a total of 7 months, the rest of world second preference date had been continuously current since November of 2012. So it seems, based on that, it seems somewhat surprising that there has been a sudden need in the current fiscal year for one, there'd be the establishment of a rest of world second preference date, and then to retrogress it 2 times in a row for April and May. This would kind of lead me to believe, was there some type of backlog that was either unannounced or unrecognized that led to this, or there were some other issues? I think that people, for planning purposes, those for rest of world and China applicants, for planning purposes, you may want to assume that the China dates are a best case scenario for the remainder of the year, and then be pleasantly surprised if any of those dates were to advance. The State Department has mentioned in the past that there might be some need for corrective action, and corrective action typically means either the establishment of a date if there isn't already one, or the retrogression if one is established. The department announced in the June Visa Bulletin for India third that it is likely that that third preference date, which is currently June 15th of 2012, is likely to retrogress for the month of July. I would, for planning purposes, you might want to assume that the July date might be, say, January 1st of 2012. If they move it back, they're going to try to control number use under that the limits established in that previous slide.
Yeah, so I think that, what's been happening in our office, and Laura, I think you could second this, is that we're on edge when we look at the next month's visa bulletin, because we basically have 2 weeks to prepare an adjustment of status filing before it retrogresses. So my little tip and advice is, don't sit on your adjustment cases, like try and get through them and get them filed as soon as possible. Because I mean, as Charlie's saying, we can't really predict what's going to happen in the next few months, but it's been this sort of erratic behavior, in my opinion, right, with all these multiple retrogressions going on.
Yeah, and it for me, it's like as I mentioned, in the rest of world employment second, to have 2 back-to-back retrogressions would be somewhat concerning. And in any area where you have already seen a retrogression, that implies heavy number use. And as you get closer to September, there are going to be fewer and fewer numbers available, potentially requiring some type of corrective action.
Yeah, and then what Laura had discussed about the EB4 now filing perms, we're really not going to see that for some time, because perms take, what, Laura, like 10 to 12 months to file?
Yeah, I mean, all in from initiation and prevailing wage determination to receiving a 9089. We've talked about this before. We're estimating between 17 and 22 months. And that is completing the steps subsequently. There are some practices where you can do some steps concurrently, but 17 to 22 months is a conservative estimate. So to Charina's point, we're not going to see that trickle effect for a year and a half at the earliest.
I mean, I'm hopeful, and what I'm hoping for is that USCIS finds all their missing cases, adjudicates them, and brings them up to, by October. But, I'm a very optimistic person. So we can go to the next slide. All right. Why did we put the family-based numbers here, Charlie? What are we trying to show here?
Well, most of these dates prior to April, or prior to May, actually, were ones that I had established when I was still chief of the office back before retirement in 2021. So they had been held for a considerable amount of time, in part because the State Department, which is responsible for probably using about 95% of the family sponsored numbers, they were digging out from a backlog created by COVID. So I think it's very positive that there's so many green listings in May. And this would indicate that the State Department is starting to try to move the dates forward in order to generate enough demand to use the amount of numbers available this year and to get people in the pipeline so that they'll be ready come October for the next fiscal year. So I think with the this is, you know, a positive thing that you see the green.
So what's going on in F2A?
F2A, it is a very interesting phenomenon. It first became current in July of 2019. And when I did that, I assumed that within a month or two, I was going to have to reestablish a final action date. That did not happen. Even though there were, quote, plenty of eligible applicants who had petitions, the demand was just not coming forward and being utilized. So that case, there was lots and lots of cases that were eligible. As I said, often people are not finalizing or submitting the required documents in a timely manner. They have finally started to do so, and therefore the 2A demand is exceeding the supply of numbers that are available.
Okay, so they went backwards by almost 2 years or 3 years, right?
Yeah, they basically had to draw a line in the sand. And the good thing is when they do that, when they establish that September 8th of 2020 date for the month of April, in my time, that would be my line in the sand where I would hopefully, in a worst case, I would hold it for a number of months and at some future point be able to slowly start advancing it once you had more visibility and demand.
So do you think this will move F2A?
It's hard to say. Hopefully the date will slowly start moving through the remainder of 2020 and on into 2021. But it's probably too early to say at this point. It's kind of a wait and see. Again, I would advise people to look, if 2A is your category, look at the application filing dates, which are in the chart B, because that is likely to represent where you might be able to expect the final action date to be in 8 to 12 months.
Yeah, I mean, this is cropping up in the employment-based side, because to be honest with you, we have situations where the family members were left behind and their adjustments weren't approved with the principal. And so now we're talking to the principals and saying, hey, you might want to file an F2A, you know, because we don't know if the EB3 or EB2 categories are going to move forward. But it's looking like for F2A, it's also going to be backlogged as well. So, yeah. All right, let's go to the next slide. So let's talk about EB2, EB3 rest of world retrogression. So the possible reasons why, Charlie, I know you've touched on it before. You want to highlight it?
Yeah, I mean, did either USCIS or Department of Labor have backlogs that were either unreported or possibly just unnoticed by people? And is the reason for retrogressions and the having to establish date the fact that in sometime in late fiscal 2022, did they start addressing that backlog and more of the demand is coming forward now and requiring use of the visa numbers?
Yeah, and I think that like Laura and I, our running joke is maybe there was a storage unit that was not opened for many years.
Well,
with all these files in them.
Yeah, they found files in a locked door, and then they opened it, they said like, whoa.
It's one of the things, having been around forever, I can remember back in the 2005 timeframe where the Department of Labor did have a significant backlog of petition, approvals of petitions, and it took them a while to kind of dig out from that backlog of pending petitions that they had to adjudicate.
There's still,
And again, it's important to remember that if there are DOL, Department of Labor cases that need to be done first, they have to be done before they flow back to the USCIS for processing.
yeah. So Laura, I'm still getting the my friend's adjustment got approved in 6 months. Why is mine still taking 1 year? And so what do we tell those people?
Yeah, I mean, honestly, the 6 month is really an anomaly. Like that was a really bizarre processing timeline. Like we talked about in last month's session, the average is really about a year. And frankly, it's, trending longer. So someone who gets it for 6 months that was really rare and unusual. And it seemed like they were grabbing USCIS, that is, was grabbing from the top of the pile to just meet numbers. Again, without knowing. That was sort of anecdotally what we were experiencing with our clients. So that's very rare and should not be the expectation.
Yeah.
And as you mentioned, also impacting processing times is the limits of recent years have been much higher than normal. And although you would assume that the quote boxes of pending cases are going to be processed in a first in, first out basis, it's possible that people are grabbing a box and it may not be a first in, first out box system.
Yeah, and I know they're still sending adjustments out. USCIS is still sending adjustment applications out to the local field offices because we're still getting RFEs from the local field office for medicals and stuff. So I know that that's still happening. So what's the impact? We put a couple things here. The US unable to address the critical shortage of nurses, which is where I said before the nurses usually fall in the EB3. And then national interest waivers is no longer an expedited pathway. So Laura, do you want to talk about the national interest waiver?
Yeah, I'll chime in here. So national interest waivers for our rest of world population, these would be folks that, a common profile we've seen are, someone who's working with AI or semiconductors, things that the government and technology are on the cutting edge here. You could file national interest waiver, which could be a faster process for filing directly with I-140 and eliminating the very lengthy perm process, as we've talked about before with DOL, is between 17 and 22 months. So great option for folks that qualify. But the rest of the world now is facing a backlog. So it's no longer an immediate pathway for a green card. So the guidance here is if you're thinking you may qualify for national interest waiver, if you're interested, you're going to want to start that process much sooner than maybe you were using it as a back pocket option to file for green card, knowing that you could sit in your H-1B for a while and not worry about it. You're going to want to start this process much sooner because you're going to be facing backlogs. You're not eligible immediately to file that green card. So it changes some of the strategy or for folks that didn't have to think about things like that.
And also the children that are aging out, right? You basically will lock the date of your child when you file the adjustment, but if you can't even get to the adjustment filing because there's retrogression, then that's going to be problematic as well. So.
Yeah, and it's important in this identification of the critical shortage of nurses that the past 3 years annual limits have been the quote best case scenario for in terms of visa availability in the third preference category where the nurses are. This critical shortage was addressed back there was a similar shortage back in 2005, which was addressed by the Real ID Act of 2005, which was able to quote they were able to recapture 50,000 numbers, which were made available to nurses for processing. And this was an effort to address the nursing shortage, which was facing the US at that point in time.
Do you think it'll happen again, Charlie? Or
it would require
Congress?
As it did then, it would require legislative action on the part of Congress. But again, there were tremendous lobbying efforts at the time because there was such a critical shortage of nurses in hospitals, nursing homes, healthcare facilities. The Congress realized this was a need, and they allowed for the recapture of the 50,000 numbers. So there was the normal third preference limit, and then there was a quote second pool of numbers. So people, basically the people in the third preference had 2 shots at numbers each month under the original, that limit, plus numbers available under the 50,000 that were recaptured. And all 50,000 numbers were used, I believe, by about February of 2007. But again, it requires legislative action.
Yeah, okay. Well, let's move on to our questions that we have. Can Charlie indicate his perspectives on EB3 India dates movement for this fiscal year?
Yeah, again, as published in the June Bulletin, the State Department believes there's likely to be a retrogression of the India date for July. Therefore, I would say that the June date is the best case scenario for India third this year, and you're likely to be seeing more significant wait times once the date does retrogress.
Okay, so right now, India third is at June 15, 2012, and EB2 India is at January 1, 2011. So we're still seeing faster movement in EB3 India. Okay, Laura, the second question, I'm not sure I understand it, so maybe you can be out here with this one.
But I think there's some room for interpretation. So current title is what's on the I-140. So I read that as your current title is what is also on the approved I-140. That's how I'm going to understand this. The role today has far more duties. HR refuses to approve title change. What to do? So it sounds like maybe the role is changing. Maybe you're becoming more senior. So we'd want to look carefully at what you mean by more duties. If more duties means you're managing individual contributors and you're not an individual contributor anymore, you're having direct reports, that's a pretty good indication that you'd need to relook at potentially a new H-1B or amending your H-1B, given that the role has changed, and that potentially going through the perm process again for the new role. So if that's how I'm reading this. If it really is just you have more projects under your role as an individual contributor, you're more highly productive. I'm not sure that qualifies as a need to amend the H-1B or change or do a new sponsorship with perm rather. So I'm not really sure exactly where this question is, but you can always reach out for a consultation with the team to dive in a little further. I think, we're looking at this from an immigration perspective. There might be business reasons why your title doesn't change and why HR has to stick to some sort of policy. From an immigration perspective, we're wanting to understand, like, what do you mean by duties? What are those duties? And does those duties put you in a different occupational category?
Yeah, so for example, we always get people who get their title changed, right? But we don't really look at the title. You can go from a software engineer to a senior or to a manager. What we're really looking at is the duty. So the question we will ask you is, what percent of the time are you actually doing management, right? And if you come back to us and you say, no, 90% of the time I'm still doing the same role, I just have an expanded role and I have 5 people reporting into me and I spend 10% of the time doing that, then really is that a different role, right? And so those are the types of assessments we would be doing. So there's no, what Laura's saying, there's no cut and dry answer, right? It just depends on the situation.
Further analysis, but giving you some boundaries to think about, to think about it, really.
Yeah. So how did EB2 rest of world retrogress despite record high EB2 visa allocation in fiscal year 2022? Well, I think Charlie covered that again, but do you want to respond again to that?
Yeah, again, it's a little puzzling to me. One possibility is during fiscal 2022, there were over 55,000 India employment second preference cases that used visa numbers. So were rest of world cases, languishing while the India second preference quote backlog was being addressed? Or as mentioned earlier, was there an unknown backlog of rest of world cases that needed to be processed, the petitions approved, et cetera? It's kind of an interesting situation.
Yeah, and then is there also a possibility of EB3 India retrogression fiscal year 2024?
Ideally, no. As mentioned, I believe that date will retrogress for July. Once they retrogress it, my policy had been to do a retrogression one time as a line in the sand that I could hold, and then at some point start moving forward. In an ideal world, they will be that the India third date for October may be able to recover some of the retrogressed grant land that they need to recover from once the new annual limit for 2024 is available. But they should have a good picture of the India demand situation going into 2024. Therefore, they should not need to retrogress that date again in 2024 in an ideal world.
Yeah. So the next question, I don't like the word discrimination. Let's just call it unfairness. Like, is it unfair that 2013, 2014 EB India got their green card and 2009, 2012 is still waiting for it? It is unfair. I mean, yes, but as Charlie said, and as Laura has been saying, we're not quite sure what the process is with the USCIS and this whole first in, first out. I mean, granted, if your priority date is current, then theoretically in a fair situation, then your case would have been processed first, right? But, Charlie, do you have any comment to that? Having the government in the before?
Yeah, it's just kind of in the India second preference category. It is kind of interesting because the dates which have applied to India second preference applicants throughout most of the last year were covered by this year's dates. So they were eligible for processing last year, these India second preference cases. Over 55,000 numbers were used, yet you've got these people languishing. It's possible that newly filed cases were easier to adjudicate than the cases which much earlier priority dates were harder to adjudicate. And if you're trying to maximize number use, you're going to go for the low-hanging fruit and do the easiest to process cases first.
And our firm actually handles mandamus action. So we have a litigation arm within our firm. So if you want a consultation with our litigation arm because you feel like, that your case is languishing and you're seeing others getting approved before you, then please do reach out and talk to our litigation team. A little compliment from you, Charlie. Just looking to glean Charlie's great insight as always. Yes, thank you, Charlie, for always doing these chatting with Charlies with us. And with that, we have a couple more slides just to close it out. Our next webinar will be on June 21st. So we can go to the next slide. So there's a typo there. It's just say June 21st at 11 a.m. Again, all our prior webinars are on YouTube, so you can catch up there. And I look forward to talking to Laura and Charlie next month. Thank you.
Thank you all.